Good afternoon, everyone, and welcome to the sixth installment of CMC's 2019 OSHA webinar series. I'm glad you decided to join us as we talk about how some of the last rules created by the Obama-era OSHA have fared in the Trump administration. We've got a lot to cover today, so we'll get started without any delay. We are going to forego our full introductions. But I'll just note that all of your presenters are members of Carry's national OSHA practice, and we represent our clients on a wide range of safety and health issues. Joining me today is Kate McMahon, who has a background as an advisor on the Hill and who has led industry's response to most of the chemical rulemakings in the last 2 decades. My name is Micah Smith, and I am an OSHA litigation specialist. I've represented employers on most of the standards that OSHA has promulgated, but I have a specialty in PSM, Process Safety Management. Dan Deacon is also with us. He has a background as a judicial clerk and has been practicing with Carry, working on both OSHA and employment law defense work. And the last member of our team today is Beeta Lashkari, who was formerly of the CSB, an attorney investigator there, and we're glad to have her as a member of our team, now representing clients as well. So let me give you a quick overview of our agenda today. We're, of course, talking about rulemaking and the fate of rules. The first section that we will cover is going to be markers in the rulemaking history here of the Trump administration. So we're going to talk about the regulatory environment, both in the Trump campaign, then in the early days of the Trump administration, as well as some of the early or broad actions that were taken by the administration. The next section will focus on the deregulatory actions under the Trump administration, talking about some of the biggest, the boldest, or most clear examples of deregulation that the administration undertook. We'll shift then to talk about some of the rules that were not rolled back. They may have been modified or challenged, but survived at least at some level. Fourth section, then we'll talk about some of the more successful rules, whether they were Obama-era rules that not only escaped rollback, but are now in effect and being enforced. We'll also talk about some of the rulemaking that has been initiated or at least continued under the Trump administration. And then we'll close with a discussion of the Obama-era enforcement policies, talking about how the rules that have been in place, how the enforcement's going. So that's a quick overview of where we're at. And I'll kick things off by talking about the rulemaking markers since the inauguration. We start off in what seems like last week, or maybe it was a million years ago, but was actually 4 years ago today, when candidate Trump came down the escalator there in Trump Tower to kick off his campaign. Some of the key features of his campaign were discussion of the deconstruction of the administrative state. So even on the campaign trail, he was talking about getting the federal government out of your workplace, trying to decentralize jurisdiction, allow states to do more things. There was a lot of talk about job creation, easing of regulatory burdens, and of course a lot of talk of rolling back some of the rules promulgated by the Obama administration. Not germane particularly to our discussion here. There was a lot of focus on EPA rules, whether it was Clean Water Rule or Waters of the U.S. Those, of course, were talked about much more than the OSHA rules were. The quote that we have here on the right of the slide in the blue block is actually from Steve Bannon during a talk he gave at CPAC back in 2017. It really encapsulates what we consider to be the administration's goal and their tactic as it came about with deregulation. There was clearly a focus on selecting cabinet members and putting people in positions of power so that they could work to deregulate things. And Bannon and presumably Trump saw this as a contrast to the progressive policies that they had seen during the Obama administration, where they had worked to push the agenda by way of regulation because they couldn't achieve these things through Congress. So that really sets the stage for what was coming. And right out of the gate, we began to see some actions in the administration that pursued this goal. Within a week or two of the Trump's inauguration, he signed Executive Order 13771 entitled Reducing Regulation and Controlling Regulatory Costs. We typically refer to this as the 2-for-1 executive order, wherein the order required that if any executive agency wanted to promulgate a new rule, they had to select 2 existing rules to be eliminated, and they imposed the additional guidance that you had to make this a zero-cost proposal. So this was right out of the gate, and so as we were watching the administration, we thought, wow, this is really saying something about what's going to happen and how much they're going to allow agencies to regulate, or how they're going to focus on deregulation. So the executive order was signed. OMB provided some guidance that nobody really read, and it was provided some information, but didn't actually give us a whole lot of information about how things were going to be done. And this became somewhat obvious as we saw some of the litigation challenging the executive order. Public Citizen brought a lawsuit against the administration, arguing that the executive order was not permissible. During oral arguments in the last year or so, the judge challenged both sides on this issue, questioning the plaintiffs about whether they had standing to challenge the executive order, but also asking the government whether having an executive order in place like this established some kind of a shadow regulatory process wherein the government was taking actions, but it was the public would be unable to know what was the real motivation for what was being done. Were they deregulating, or were they knocking down a rule because it was a bad rule, or were they knocking down a rule because they needed one to match the quota because they had a new rule they wanted to put out there? So this case is actually ongoing nearly more than 2 years after the Trump administration began. The judge has, it's basically the ruling so far focusing on standing. The judge has found a lack of standing, but has given the plaintiffs additional time to prove their standing. So the parties are continuing to file things even this month. So we will be watching this case to see if there can be any legal challenge to this executive order. Moving a little closer to home, at least for our purposes, is looking at the Department of Labor. Alexander Acosta was confirmed as the Labor Secretary in the spring of 2017, and shortly after he was confirmed, he wrote an op-ed and published it in the Wall Street Journal, one that for those of us who are lawyers and very focused on agency actions, and we rely on the predictability of the rule of law, something that we saw as something that was a bit comforting. Secretary Acosta endorsed the approach of the Trump administration to roll back regulations, but he noted that the Department of Labor would only be doing these types of things in a way that followed the law. He spoke up and put out there his commitment to follow the Administrative Procedures Act, and said that his agency would be doing everything that they intended to be doing in a way that was lawful. So as we were watching these very strong actions, executive orders by the Trump administration, statements by Steve Bannon, we saw in Secretary Acosta's remarks kind of a counterweight to that there was a support for deregulation, but at the same time, not a willingness to do just anything in pursuit of that. So with that, that's your background. That's what we saw coming into the Trump administration. Now we'll shift over to talk about the deregulatory efforts, and I'll turn that over to my colleague Dan Deacon.
Great. Thank you very much, Micah. This is Dan Deacon speaking, and now we're going to turn into what happened in January 2017 when the Trump administration came into office, and those immediate efforts to start slashing regulations. And we're going to go over how that actually played out. And from the beginning, we'd be remiss if we didn't talk about the Congressional Review Act and what happened immediately following the inauguration. And that was, what we saw was an unprecedented and a historical use of the Congressional Review Act. So just as a brief background, the Congressional Review Act was passed in 1996 as part of then Speaker Newt Gingrich's Contract with America. So while executive agencies can only issue regulations pursuant to statutes passed by Congress, Congress wanted some type of oversight and a way to make it easier for them to actually overturn those regulations. So that was the basis and the genesis of the Congressional Review Act. What it did was create a period of 60 session days, 60 days in which Congress is in session, in which they could use expedited procedures to overturn a regulation. So it's really used primarily during transition periods when a new party takes office in the executive branch and the former administration passed regulations in the waning days of their term, most commonly referred to as midnight rules or regulations. And it's typically only going to be successful, using the CRA is only going to be successful in circumstances in which the president takes office and where one party has a majority in both the House and the Senate. And that's what we saw in January 2017. So since the CRA became law in 1996, there had been more than 120 resolutions of disapproval that had been introduced to cancel regulations, but it's actually only been used successfully once prior to the Trump administration, and that was actually an OSHA rule, President Clinton's midnight ergonomics rule. However, President Trump changed all that, again, as I mentioned, in historical fashion, and he used the CRA to slash a number of Obama-era rules, including a couple notable OSHA rules.
Hi everyone, this is Kate McMahon. I want to spend a minute talking about what Dan just led into, which is the use of the Congressional Review Act to get rid of, eliminate a regulation that had been promulgated by the Fair Acquisitions Regulation Council in conjunction with the Department of Labor 3 months before the November 2016 election of Trump. In August of 2016, under the Obama administration, the Fair Pay and Safe Workplaces Rule was promulgated. It was known in the contractor community as the Contractor Blacklisting Rule. It was broadly applicable to all government contractors and subcontractors to general contractors, and it was extremely unpopular, hence the name, the Contractor Blacklisting Rule, among defense and other contractors, all government contractors, in fact. Essentially, the regulation required the initial and then continuous disclosure to the contracting agency of essentially all violations of a slew of labor laws. I think there were 14 labor laws that were covered by the FAR regulation, including OSHA regulations. So if a contractor or a subcontractor of a contractor received an OSHA violation, it had to be disclosed to the contracting agency. At that point, depending on the seriousness of the disclosure, the contracting agency had broad authority to, again, depending on what the disclosure was, had broad authority to essentially rescind the contract, debar the entity possibly, and or set up these labor compliance agreements where the contracting community anyway believed they had very little leverage in negotiating those agreements. So very, very unpopular regulation, very popular with the worker community and the progressive community in the summer of 2016, just shortly before the election. Fast forward to January 2017. Shocker, President Trump is elected president, and within a few months we have I believe the first, Dan's going to talk in a minute about another OSHA rule that was CRA'd, if you will. I think this was first. The FAR regulation was CRA'd just a few months after Trump became president. On March 27th, 2017, the FAR regulation was booted. Congress, both houses voted pursuant to the requirement to meet the Congressional Review Act threshold, and the President signed into law the repeal of the FAR blacklisting regulation. So that was essentially gone. And then Dan's going to talk about the second use of the CRA in the OSHA context.
Great. So one other very important rule that was subject to the CRA is what was known as the Volks Rule, and that had expanded the statute of limitations for record-keeping violations from 6 months to 5 years, basically. The final rule was published during the final month of the Obama administration on December 19th, 2016, titled Clarification of Employers' Continuing Obligation to Make and Maintain an Accurate Record of Each Recordable Injury and Illness. And the Obama administration issued this rule to essentially overturn a 2012 decision by the D.C. Circuit, which held that OSHA could only cite record-keeping violations within 6 months from when the injury was first due to be recorded. So the clarification piece of this rule was to reverse that decision and emphasize that and reaffirm that employers have a continuing duty to update their injury and illness information for the 5-year period that they're required to preserve records under OSHA's record-keeping regulations. So under that final rule, the statute of limitations essentially became 6 months plus 5 years. And that was met immediately with criticism from industry, and it was ripe for the new administration to slash it through the Congressional Review Act, and that's just what they did. Both houses of Congress and President Trump signed a joint resolution disapproving the Volks Rule and returned that statute of limitations period for record-keeping violations back to 6 months from the date of the injury or illness when it should first be recorded. So notably, from the D.C. Circuit's decision to promulgation of the Volks Rule, record-keeping violations had dropped by about 75%. So the Volks Rule would have opened up the door to a significant amount more of enforcement authority, and we would have likely seen those record-keeping violations spike. The use of the CRA here was certainly welcome by industry, and that was a good rule. Note, however, if you are in California, I guess there's some bad news for you. So California, within the past year, passed through legislation Assembly Bill 2334, which expanded the statute of limitations for Cal OSHA to issue injury and illness record-keeping violations back to that 5-year statute of limitations period. So despite the D.C. Circuit's decision in Volks and a Cal OSHA Appeals Board decision, which held that Cal OSHA cannot cite employers for failing to record injuries and illnesses if the violation took place more than 6 months before the citation was issued. That Assembly bill, it was passed by the General Assembly, so it's legislation, it's not a rule, and that 5-year statute of limitations period is now on the books. In other words, the California State Legislature reinstituted the Volks Rule through legislation. So again, if you're an employer with establishments in California, you are subject to a 5-year statute of limitations period for record-keeping violations. So the next rule that we're going to talk about now, it was not subject to the CRA, but this is in the spirit of scaling back regulations and the Trump administration's efforts to do so. So this rule that we're talking about now is the E-Recordkeeping Rule, a rule that is still relevant and a topic of discussion today. So this rule was passed back in May 2016, and it was a pretty big rule at the time that industry was immediately critical of and disapproved. The nuts and bolts of the rule was that establishments with 250 or more employees would be required to submit their 300, 301, and 300A data to OSHA on an annual basis, and establishments in high hazard industries with 20 or more employees would be required to submit their 300A data on an annual basis. OSHA also snuck in some controversial anti-retaliation provisions related to post-incident drug testing, safety incentive programs, and reasonable reporting procedures. So there's actually 2 active lawsuits that are related to this rule in the Northern District of Texas and the Western District of Oklahoma. They're ongoing, so the challenge to this rule is still not over. But the administration did attempt to ease the burden on employers pretty soon after taking office, although this proposal and the ultimate final rule was far from what industry had hoped for. In President Trump's fall 2017 regulatory agenda, he announced OSHA's intent to revise the E-Recordkeeping Rule, notably removing that requirement for large establishments, those with 250 or more employees, to electronically submit their 300 and 301 form data. Shortly after that, without any rulemaking, OSHA had updated their instructions on their injury tracking application, instructing large employers that they didn't have to submit that data during the second round of data submission, even though technically they were supposed to. OSHA hadn't, they didn't have the goal to collect that data to begin with, but also the injury tracking application wasn't even set up to collect it. And then what we got a year or so later was a proposal from the Trump administration to scale back that rule, removing the requirement for large establishments to submit their 300 and 301 data, and also adding a new provision requiring employers to submit their employer identification number. So that final rule, or the proposed rule I should say, was adopted as is in January 2019. Both proposals were adopted. The most recent data submission in March of 2019, they did not collect the employer identification numbers, but that will be collected going forward, beginning with the March 2020 data collection. So one other very interesting development that just happened recently was related to Phase 4 of the Standards Improvement Project and OSHA's initial proposal to rewrite the Lotto standard. So this was actually moved, SIP Phase 4 was moved to the final rule stage in Trump's first regulatory agenda, Phase 4 of the Standards Improvement Project, and it was somewhat surprising at the time given that controversial rule that was included in the initial proposal. And that was to remove the term unexpected energization from the Lotto standard. And historically, the Standards Improvement Project was used to make these non-controversial minor changes or clarifications to standards, some that were confusing or outdated. However, here the Obama administration was attempting to use it to basically remove and rewrite an entire standard. And that term, unexpected energization, had become a very important defense for employers, especially since the Sixth Circuit's decision in the GM Delco case back in 1996. And in that case, the Sixth Circuit held that the standard unambiguously renders Lotto inapplicable where employees are alerted or warned that a machine or piece of equipment is about to activate. And it applies where a service employee is endangered by a machine that can start up without an employer's foreknowledge. So in other words, it's not unexpected if an alarm is giving you a clear, audible, or timely warning. The controls are located so the servicer's aware of when the machine is starting up. And that had been something that employers relied on now for more than 20 years. So what happened last month, basically a month from today, or give or take a few days, was the final rule was published for SIP Phase 4, and what was notably missing from that was a change to the Lotto standard. So the decision to remove that provision from Phase 4 of the Standards Improvement Project may not have been the last word on this, however. OSHA, in the final rule, stated they continue to believe that the GMC Delco case was, they misconstrued the unexpected language of the Lotto standard, and that the agency will not finalize its proposal to remove the word from the control of hazardous energy standard, but it's going to continue considering this issue going forward. The next day after this final rule was published, OSHA issued an RFI, or it may have been a week later, about potential changes to the Lotto standard based on new energy control technology, which could open the door for further discussion about this unexpected energization issue. However, it was not specifically addressed or requested as a topic for information in that RFI, but it certainly opens the door for such.
So this is Kate again. So, one of our main goal in this webinar is not necessarily to teach our audience the details and ins and outs of the various regulations or changes to rules that we are discussing here, but we're really using these as sort of exemplars to attempt to describe what we're seeing 2.5 years into the Trump administration and how the regulations that were promulgated mid to tail end of the Obama administration have fared, as Micah said at the outset. So really, it's very difficult there is nothing black and white, I guess is the best way to say, what we are seeing so far. We are not seeing, by any stretch, the deconstruction of the administrative state as was announced by Steve Bannon, and President candidate Trump at the outset. They started out, as we started out this webinar describing, with a bang. We had, in our little world of OSHA and labor, we had two regulations CRA'd, as Dan and I described a few minutes ago. That is a very bold, dramatic, and radical move. We had only seen it happen once before with the ergonomics rule that was promulgated at the very end of the Clinton administration. And so, if you're sitting in your chair as an employee, as a labor group, or as an employer in spring of 2017, just a few months into the Trump administration. Oh, and by the way, the other thing that happened early on is Trump announced that Andy Puzner would be his nominee for the Secretary of Labor position. That, as you may remember, kind of fell off the wheels a few months, about a month after the inauguration, for some reasons unrelated to what we're talking about, personal issues that Puzner had. In his place, the next day after he withdrew, Trump nominated Alex Acosta, who we mentioned earlier does not seem to be in the sort of radical Trump vein of Steve Bannon, Trump deregulation. He's a former Bush appointee. He is a more moderate Republican, at least compared to the Trump, some of the other Trump nominees, like what we had seen at EPA and what we think Puzner might have been. Anyway, point of this all is that what we are seeing here is we're seeing essentially a very mixed bag. We're seeing some deregulatory efforts that are successful. We're seeing a lot of efforts that are, I guess you would say, deregulatory in nature, but they're moderate, as Dan just described with the E-Recordkeeping Rule. That rule did not go away. That rule is modified. It's less burdensome to employers, but it's still in existence. Lotto, the SIP-4, basically that can be described as the Trump administration pulling back something successfully that the Obama administration was attempting to do using SIP. Probably, at least arguably, not the best way to revise Lotto. If you're going to do it, you need to have a rulemaking on Lotto and get rid of the words that Delco clearly say mean something. But we had the administration saying, the agency saying, that there's more to come on that. And that could be sort of a waiting game to see what happens in 2 years at the election. Bottom line, it's a hodgepodge where we do have some regulation that is successful, at least in the terms of the Trump administration, killed or, really pulled back. We then see some Democratic action that puts it back in play. And a perfect example of that would be Beryllium. With just 11 days or so before the end of the Obama administration, Assistant Secretary of Labor, David Michaels, promulgated the Beryllium Rule. It applied to all sectors of industry, general industry, maritime, and construction. General industry standard is alive. It's in place now. It is. There was a lawsuit. There was a settlement of that lawsuit. There will be some modifications to the rule, but it is a rule. It's robust. It's there, and it will be there permanently, assuming this administration, makes the revisions that they have proposed. However, on the construction and maritime side of the House, notwithstanding the fact that the final Beryllium Rule, promulgated 11 days before the inauguration, covered those industries, in June of 2017, just 6 months into the administration, the agency proposed to withdraw all provisions of the rule applicable to the maritime and construction industries or sectors, except for the Pell and the Stell. The permissible exposure limit and the short-term exposure limit were left in place, but they got rid of everything else. They really wiped out the comprehensive nature of the protections of the rule as applied to maritime and construction. That, you would say, would be an example of real deregulation. But just last week, Congressman Bobby Scott from Virginia, the Newport News, Norfolk area of Virginia, led the passage of an amendment to the Labor Appropriations Bill that prohibits the Department of Labor, OSHA, from using any funds to finalize or implement that June 2017 proposal to essentially wipe out much of the Beryllium Rule as it applies to construction and maritime. So here's an example of even where the administration seemed to be fairly successful in its effort to deregulate. We've got the House, the now Democratic House, coming in and stopping or halting the finalization of that deregulatory action in the context of Beryllium. What else do we have here? Oh, and so now I'm going to turn it back over to our RMP PSM guru, Micah Smith, to talk about what is happening in the PSM RMP world.
Yeah, we think there's probably no better example of the mixed bag outcomes of this administration's regulatory approach than you see in RMP and PSM. We'll start with RMP. Just a quick background for anyone who wasn't paying attention in the last year of the Obama administration. EPA in Obama's second term committed to reform the RMP during the time that Obama was president. So you saw the project kick off, as I said, in the second term, but then you saw what would turn out to be just lightning speed as it relates to administrative procedures. You had the Small Business Review Panel meeting from September to March 2016. You had EPA issuing a final proposed rule, somewhat limiting the scope of the proposed reform in an attempt to get it done by the end of the administration. Those amendments were published in March 2016, even before the SBAR report was finalized. There were multiple extension requests made during the rulemaking. Those were all denied. The rule was rushed to OMB for expedited final review and approval, and the rule was published on January 13th, 2017. So we've got the Obama administration, EPA, successfully pushing through a reform rule very, very fast, getting it in at the last minute. So, we would expect coming in at the beginning of the Trump administration, we've got this great tool of CRA, let's knock out this Obama-era midnight rule. And Congress, there were a couple of bills entered, I believe one in the House and one in the Senate, to use the CRA to strike it down, but those did not go through. They didn't move fast enough, and so CRA was not successfully deployed. In light of that, EPA in April and June of 2017 published rules delaying the effective date of the RMP reform rule. Once those delay rules were published, you had nearly instantaneous court challenges by interest groups. You had those cases taking up to a year to be litigated. We had a very big decision from the D.C. Circuit in September of 2018, wherein they vacated the delay rule. So for those following along at home, the Obama-era EPA published a reform rule, we'll call it the reform rule. The Trump-era EPA published a delay rule, that is, they're going to delay the implementation of the reform rule. Then you have the D.C. Circuit vacating the delay rule. So with the delay rule gone, we now have the reform rule made effective essentially immediately. As we sit here today, the RMP reform rule is in place, is effective. It is somewhat unclear how much or to what extent EPA is actually enforcing that rule, but it is on the books. It is the law of the land. With that said, this story isn't over. EPA began implementing, or they proposed a rule to roll back nearly all of the Obama-era reform rule. That rulemaking is still ongoing. It was promised to be finalized in January or February of this year. As you'll notice, it's June, and we're still waiting for that proposed rollback rule to become final. In the regulatory agenda published this spring, it seemed to indicate that EPA was going to continue working on this, but it would become final later in the year. Once you've seen a final rule delayed by 6 months or so, it gives you reason to question whether it will successfully be finalized or not. So where we stand right now is it's hard to call it anything other than a botched attempt so far to roll back an Obama-era rule here on the RMP. So while, in contrast to the movement on the RMP rule, which EPA successfully rushed through at the end of the Obama administration, OSHA continued to move forward with its PSM reform rule through the end of the Obama administration, but didn't seek to rush it through. OSHA did complete the SBREFA process in the summer of 2016. It identified a number of issues that could be addressed in rulemaking. There is considerable overlap with EPA's RMP rulemaking, and you've got a list here of items that were going to be, it seemed that they were going to be addressed in a PSM reform rule. We arrived at the beginning of the Trump administration, and this rule that was probably getting close to being ready to be issued as a proposed rule, then it is moved from in the OSHA regulatory agenda from the active agenda to the long-term agenda. Today it remains on the long-term agenda. We have statements from OSHA personnel, including at our last year's Process Safety Summit, saying that OSHA is continuing to process comments from the RFI and SBREFA panel, but there is absolutely no guidance or no comment available on when this long-term action will be continued. So this is something that is still a live rulemaking. It's out there. We don't have a proposed rule, but it seems that OSHA could at any point move forward with the next steps, which the most obvious of which would be a new proposed rule for PSM. So, here we have, I would say, the Trump administration successfully slowing down the process of the PSM reform rule. unsuccessfully rolling back the RMP reform rule. And so that's your mixed bag. If you're in an industry that has process safety concerns, we have some uneven rules, whereas before PSM and RMP tended to track each other, we now have a number of provisions that are effective under EPA's RMP rule that don't exist under OSHA's PSM rule. Continuing, I'm sorry, that's the end of our sort of mixed bag section. I'll toss it back over to Beeta to talk about some of the more successfully implemented rules in this administration.
Great, thanks, Micah. So yes, in this section we'll be talking about some of the rules that have largely stayed the same or even been enhanced since the Obama administration. And we'll start with silica. So in March 2016, OSHA finalized its respirable crystalline silica standard, and enforcement is now in full force. So taking a step back just for a moment, what is silica? Silica is a component of soil, sand, granite, and other materials, and it's ubiquitous, meaning it's everywhere. The problem with that is that crystalline silica is a human lung carcinogen. So OSHA developed this standard to protect the some 2.3 million workers that are exposed to silica in the U.S. So how did OSHA develop this standard? Well, it developed two sets of rules, one for the construction industry and one for general industry and maritime. And for the most part, the two sets are pretty much the same. They both have the same permissible exposure limits, or PELs, as Kate mentioned in the beryllium section, and they also have the same action levels. They have similar provisions for written exposure control plans. They both limit housekeeping, which can result in exposure, and they both include requirements for medical surveillance, training, and record keeping. The major difference between the two lies in the fact that the construction industry silica standard includes something we all refer to as Table 1. So what is Table 1? Table 1 is sort of a carve-out or exception for certain equipment or tasks in the construction industry. What it does is it matches common construction tasks with dust control methods that have been shown to be effective. So without getting into too much of the details on all of this, what it allows for is for employers who follow it to forego the requirements of measuring silica exposure or being subject to the PEL. This was OSHA's way of sort of saying to employers, if you follow Table 1, you're good. But again, that's only for the construction industry side. So as the Trump administration came in, we thought we might see some movement and some change in the standard for construction, particularly with respect to Table 1. OSHA announced that it was interested in information on the effectiveness of control measures that are currently not included for the tasks and tools listed in Table 1, as well as in, you'll see in the second sub-bullet there, tasks and tools involving exposure to silica that are not currently listed in Table 1 and the effectiveness of any related dust control methods. OSHA said and continues to say that it intends to evaluate the available information to determine if revisions to Table 1 may be appropriate. So where are we now? Silica is still listed in the pre-rule stage in the spring 2019 regulatory agenda with a request for information or RFI date set for May 2019, but as we know, that's passed. So while we don't know what, if anything, is coming with respect to the silica standard for construction, what we do know is that it's not going anywhere fast. So this just provides an example, and my colleagues will present more, of an Obama-era regulation that has not changed and that remains in full force. I'll now pass it back to Micah, and he'll speak about the walking working surfaces standard.
And can I just jump in really quick? One of the reasons Beeta talked about silica is because on the chemical side anyway, the chemical rulemaking side, of all the regulations that I'd say we expected to see, Silica was, it was litigated by industry. It was not a popular rule. It was very, industry was very concerned about it. We really did expect to see some movement, and to see that Silica is in place, as Beeta said, strong today as ever, really, is really, that's sort of the part of the message here of this webinar, that we're not seeing radical change, but this mixed bag.
So one of the things we try to do is, as Kate said, we're using these rules as examples or ways to understand what's going on. One important thing to remember about the Silica rule is that it's been an objective of the Department of Labor for decades, something that's been talked about for a really long time. That has parallels to the situation with the walking working surfaces rule. You can see here the timeline of OSHA's history in attempting to update the walking working surfaces standard. The original walking working surfaces standard was promulgated just a year or two after OSHA was created, and back in the 70s. Only a decade or so later, OSHA began to see that there needed to be some changes or updates, and began the process of trying to update it back in 1990. Went through several proposed rules, multiple sets of hearings and comments. Finally, they get to publishing a final rule in November of 2016, and it becomes effective in January of 2017. This is a rule that, by all accounts, would be eligible for being knocked down by the CRA, possibly facing the same deregulatory action that some of the other rules we've talked about could have faced. But we see that you'll notice that we don't have anything here in this slide talking about deregulatory actions. It's because there haven't been any. There was no attempt to CRA this rule. There's been no attempt by the agency to roll it back, to limit it, to revise it, to reform this rule. It just remains in place as it was published. So we think that one of the important things here is that, number one, it had been long in the making, that OSHA had been working on this for a very long time. They had given it significant thought. The process for issuing a new walking working surfaces rule began in the first Bush administration. You see action during the second Bush administration. You see movement during the Obama administration, and then now here we are in the Trump administration. So this isn't something that was rushed, that was highly partisan. It was more or less an improvement, something that OSHA had been wanting to do for a long time. But with that said, there are a lot of new requirements, and we thought that seeing some of the interim deadlines of this rolling effectiveness, we could see some interesting actions from the agency. We've got the list of rolling deadlines here. The rule became effective throughout 2017 with some deadlines in November 2017, a deadline in November 2018, and then there is still one deadline that has not passed that's coming up for fixed ladders over 24 feet that is going to come into effect in November of 2036. All right, so what we've seen here is, even though this rule wasn't subject to a challenge, it didn't entirely clear the decks or make everything clear. As we have experienced the enforcement of this rule and dug in a little bit deeper, we've noticed some inconsistencies in the rule, some things that have bothered employers or have come to be concerns. One of the most important things we've dealt with is the issue of grandfathering. So that is, if you built something before the new rule became effective in January 2017, are you stuck with replacing it to meet the current code, or can you, by proving that it was in compliance with the previous version of the rule, can you then be grandfathered in under the new rule? I won't go through the details here. We've covered this in walking working surfaces webinars before, but it's entirely inconsistent. OSHA did a great job of making clear when it's allowed sometimes. They did a great job in the preamble saying when it's not allowed, and then there's a mixture of things or situations where it may be allowed. So what we see, though, during this administration are some efforts to provide clarification. And so even in a situation where we're not seeing a rule back, there are some opportunities for the interpretation to be more favorable to employers, or even the enforcement to be more favorable to employers. Here we continue to see this is a little bit of a mixed bag here. Again, the rule exists. It has not been challenged in any effective way. But there are some carve-outs where the agency is making it a little bit easier to comply with the rule. So you see this letter to the ILTA. The standard for ladders and stairs always focuses on the installation date. And so stairs or ladders that were installed before the effective date of the standard do not have to comply with the new rule so long as they complied with the old rule. What OSHA did here with this interpretation letter is they said that installed doesn't mean installed as in attached to the equipment in place in the workplace. It actually means stairs that were designed and fabricated before the standard's effective date. So you may have designed it, fabricated, it's laying out in your yard. It's not quite installed in the way we would normally see that, but that's fine. We'll still call that installed for purposes of grandfathering. So that's one way that the agency made life a little bit easier for employers. There was another interesting request for interpretation that was sent by NATE, the Association of Tower Erectors. One of those rolling deadlines was the training deadline for May 2017, when employees who were exposed to fall hazards had to be trained. OSHA declined to provide an extension on that deadline. They also declined to raise the trigger for fall protection in general industry, which is 4 feet, up to 6 feet to match the trigger under the construction standard. This would have been an interesting area where OSHA could have gone back and changed the rulemaking, or at least conceivably could have, in a way that is beneficial to employers, that makes it easier to comply. It also would have encouraged consistency between general industry and construction. They declined to do that and went with the rule as it was written. Compare this with the last bullet here, where you've got enforcement guidance for rope descent systems. There was a letter, or OSHA issued enforcement guidance saying, we know there's a deadline in November of 2017 to have all of your anchorages inspected and confirm that they're okay by a competent person. Seems like there's not enough people to do this, and it's taking people too long. So then the agency says, as long as you are working hard and showing that you're making progress in getting this done, we won't cite you for it. So on the one hand, they're not going to give, or they didn't give an extension for the deadline on training. They did give an extension for the deadline on completing inspections of anchorages. So here, the takeaway for walking working surfaces is that there's no rollback. The rule exists, but there have been a few cases where the agency is making compliance a little bit easier, or is giving employers a little bit of breathing room. So let me pass it back to Beeta, and she'll talk about HAZCOM.
Thanks, Micah. Okay, so moving on to the Hazard Communication Standard, or HAZCOM. So just to provide some background, the last time the standard went through any major changes was back in 2012, when it was updated to align with the UN's globally harmonized system of classification and labeling of chemicals, also known as the GHS. And as I'm sure you can guess, this was meant to create a uniform approach to classifying and labeling hazardous chemicals around the world. It caused the name change, Material Safety Data Sheet, or MSDS as we all knew it, to be to Safety Data Sheet, or SDS, and created a standardized set of formatting for SDSs, as well as a number of other changes as well. But without going into the weeds about the standard itself, when HAZCOM was last updated in 2012, it adopted revision 3 of the GHS, which was the 2009 version. But since then, the GHS has been updated several times and is currently at revision 7. So our HAZCOM standard, so far as the GHS is concerned at least, is quite a bit out of date. As such, OSHA announced that it would be working on more HAZCOM revisions, such as realigning the standard with a more current version of the GHS, as well as addressing issues that have come up in the years since it was implemented in 2012. OSHA has published a number of letters of interpretations, or LOIs, as well as FAQs to help employers with compliance, but considering the vast number of them, thought it might be best to address all those through rulemaking. What's really important to note here is that these changes would not be deregulatory. In fact, they would actually enhance current requirements. So OSHA was considering making all these changes for a long time, but has now moved HAZCOM to its long-term actions list. Okay, so what does this all mean so far as political administrations? HAZCOM was last updated, at least in any major way, in 2012 during the Obama administration. Then OSHA announced that it planned to further update the standard in 2014 when it first appeared in the regulatory agenda. But nothing really happened with the standard. No action was listed on it until fall 2016, right at the end of the Obama administration, as if it knew, attempts for deregulation would be coming. That is when OSHA announced that it would issue a Notice of Proposed Rulemaking, an NPRM, for the standard in October 2017. That attempt to move HAZCOM along, though, was probably too little too late. Since the Trump administration came in, HAZCOM has largely been put on the back burner. It has listed the NPRM status only as TBA, to be announced, except for in the last spring 2018 regulatory agenda, when the agency finally laid out a time frame of February 2019 for the NPRM. But as we know, that did not happen. And in the most recent spring 2019 regulatory agenda, the one now, it pushed back the NPRM publication date to December 2019. So to wrap up, even though HAZCOM has not been further updated, the fact is that Obama's HAZCOM 2012 remains in full force. And even though the NPRM keeps getting pushed back, the fact that changes, if any, would likely only enhance requirements would make it, again, symbolic of how things went differently from how we would have expected under this deregulatory regime. Okay, I'll now hand it back to Kate, and she'll talk more about enforcement.
All right, everyone. Well, so we're 3/4 into the webinar, and we've sort of given you, I think, a picture of this mixed bag of deregulation by the Trump administration. We wanted to spend the last segment of the webinar talking about what's happening on the enforcement side of the house with various enforcement initiatives, or what we're seeing in the way of violations that are being cited by compliance officers across the country. Bottom line, from at least my perspective, we're not seeing even a real mixed bag on the enforcement side. What we're seeing so far does seem to be essentially a continuation of the Obama-era, David Michaels era enforcement policies, for the most part. If you look at some of the markers, you check to see what is happening on enforcement. If there was an effort to sort of stranglehold or choke enforcement by OSHA, compliance officer counts would go down. The whole budget for OSHA would likely go down. But interestingly, last fall, we're about midway through the 2018 budget now. Last fall, OSHA got their new FY 2019 budget, and it essentially was a $5 million increase over the FY 2018 budget. Now, $5 million isn't a lot, but for a small agency like OSHA, it's something. And more important than the number is the fact that the budget went up. That was actually the first time the budget went up since FY 2014, midway through Obama's second term. So we're seeing more money going to the agency, and there's been no effective effort anyway to limit that money from being used on enforcement with any riders on the appropriation bills. And money, by the way, is going to the states as well. There was a $2 million increase in FY19 over to FY18 for state plan OSHA work. Civil penalties. We do a lot of webinars and we talk about this a lot. We don't have enough time to explain this, but suffice it to say that in 2015, actually sort of at the close of Congressman John Boehner's term as Speaker of the House, we understand there was some sort of, possibly some backroom deal that was made where Boehner supported this Federal Civil Penalties Inflation Adjustment Act, and it passed in 2015. That act does not apply just to OSHA. It applies across the board to federal agencies. But what it does is it mandates basically a catch-up it mandated a one-time catch-up for inflation for penalties issued by these various agencies, and then an annual, sort of smaller catch-up to make sure that the penalties are staying abreast of inflation. We expected, and this chart here on the screen shows you, what happened. The dramatic change for OSHA, because those penalties had not gone up in like a gazillion years. We see a huge jump in, look at the serious category of penalties, from 7,000 where it sat forever to 12,471. Well, then we see these catch-up mandates occurring each year. Trump's inauguration, January 2017, we see the bump. January 2018, another little bump. January 2019, another little bump. Now, we had, until the midterm election, a Republican president, and we had Republican control of both houses of Congress. What some expected to see was a repeal or a serious pullback on the Federal Civil Penalties Inflation Adjustment Act that required these annual mandate catch-ups. But we saw nothing of that. And so each year we will expect to see a civil penalty rise in, by a few $100s. Another marker, average penalty per serious citation. If you look what's happened, you see a continuous increase. You see the big jump from 2017 to 2018 under, of course, this president's tenure. We've got a big jump in average penalties for serious violations. And, that's another sign that on the enforcement side of the house, this is a continuation of what we saw under the 8 years of Obama. You look at repeat citations. Under Assistant Secretary of Labor David Michaels, Dr. Michaels made a huge effort to get the most bang for his buck in the enforcement arena. And one of the ways he did that fairly effectively, in my view, is he had the agency focus on issuance of repeat citations where repeats were, legit. We expected under this Trump administration to see a decrease in the use of repeat classifications. With repeats, of course, you can have a much higher penalty matrix than you can with serious. Now, if you look at the stats, you do see in 2017 a slight increase over 2016. By 2018, we do see a slight decrease in the use of repeats. So maybe this administration is not using, it has sort of shifted its philosophy on the use of repeats. But, I mean, if you compare the 5.1% to what we saw in 2002 at 2.4%, I mean, we're still almost double what we were seeing just, in the early 2000s. So repeats, I don't know that we'll see a continued rise. We'll have to watch that carefully, but we're certainly not seeing a serious pullback of the use of repeats. And then another marker that we've looked at is the emphasis programs, the enforcement emphasis programs that the agency has in place. We've seen essentially no significant change in the emphasis programs that the agency is using to set enforcement priorities and enforce the OSHA regulations. We had, under the Obama administration, at the end of that administration, we had 9 national emphasis programs. Those 9 national emphasis programs, which are on your slide there, are still in place. We have a change in the way the targeting, enforcement targeting is done. Dan's going to talk about that here in just a second, but it's not a, certainly not a rescission, it's just a revision, essentially, of the way it was done under the Obama administration and Dr. Michaels. So same enforcement programs, bigger budget, not a huge drop in the number of compliance officers, essentially a continuation of the status quo. And Dan is going to talk about site-specific targeting.
Great. So we got a few more slides to get through here, so just bear with us, and I'll give you the nuts and bolts of a couple trends that have continued in the enforcement arena from the Obama administration to the Trump administration. First one being the site-specific targeting inspection plan that was rolled out in October 2018. So this is probably one of the bigger enforcement updates in the Trump administration, and 2019 in particular. So that program was born out of OSHA's E-Recordkeeping Rule, and the idea there is that they want to target establishments for inspection based on the 300A data that is submitted through that rule, targeting what's deemed to be high hazard employers, those with high injury and illness rates. So the program itself really isn't that new. OSHA has used SST programs in the past, previously based on OSHA's data initiative. So although this isn't a new type of program, it's certainly not something that we expected under this administration. But alas, we do know that OSHA is out there performing SST inspections, and employers that are subject to OSHA's E-Recordkeeping Rule should certainly keep an eye out for a potential SST inspection. So who is subject to a potential inspection? Well, it applies to non-construction workplaces with 20 or more employees, and it's based solely on that 300A data collected from fiscal year 2016. So that's 2016 300A data that was submitted back, I believe it was December 2017. A random list is generated from the pool of data that's submitted, and OSHA uses that list and checks off each establishment that's on there, and they can't move on to a new list until each one of those establishments is inspected. So all covered establishments under the E-Recordkeeping Rule are subject to this program, but in particular OSHA is focusing on the 3 that you see on the screen here. So establishments with high DART rates, those above an unknown and unpublished threshold. So it's a little difficult to glean, whether you do fall into an SST inspection type program, whether you're within that threshold or not. 2, a random set of establishments OSHA believes should have submitted their 2016 data but did not. And then they're also going to be pooling a random set of establishments with low injury and illness rates for quality control purposes. So ultimately, everyone is subject to an SST inspection. The next couple slides here, we'll quickly go over the temporary worker initiative, and this is something that was emphasized during the Obama administration. Obama's OSHA advanced the temporary workers are covered under the standard, and host employers under the Act, and host employers need to treat temporary employees as their own, and those employers are going to be jointly responsible with staffing agencies. So again, this is a high priority under the Obama administration and something that we've continued to see going into the Trump administration. So back in 2018, 2 temporary worker initiative bulletins were issued or revised. And the nuts and bolts from these is that both the host employer and staffing agency are going to be held responsible to ensure that workers wear appropriate respirators and hearing protection when required by OSHA standards. So those 2 bulletins, they're related to respiratory protection, noise exposure, and hearing conservation. So again, the key there is going to be shared responsibility for temporary worker safety, and what's required is some thoughtful coordination between staffing agencies and employers. Now, one caveat to this, and an area where the Trump administration was perhaps trying to change the joint employer analysis, was through the NLRB. Under the National Labor Relations Act, there was a decision back in 2017, High Brand Industrial Contractor, which overruled the joint employer liability standard that was set previously in the Browning-Ferris case. So what the High Brand case ultimately held was that if there's two or more entities, that they would have been deemed joint employers under the Act if there's proof that one entity has exercised control over essential employment terms of another entity's employees and has done so directly and immediately in a manner that's not limited and routine. So that board decision was vacated 2 months after it was issued for some ethical concerns. One of the board members' prior law firm had handled the Browning-Ferris case. So currently that Browning-Ferris case is up for appeal before the D.C. Circuit, but we are back to the Browning-Ferris standard right now, which stands for the proposition that if an employer retains the right to control another employer's employees, regardless of whether it actually exercises that control, such control, that minor control, is sufficient to establish a joint employer relationship over those employees. So again, this is going back to the D.C. Circuit on appeal, so we'll see what happens. And the outstanding question going into the next 2 years here of President Trump's term is, are they going to be doing anything to revise the joint employer standard in the near future? And what we've seen on a different side of things is the Fair Labor Standards Act. I think it was back in April 2019, a notice of proposed rulemaking was issued revising the joint employer standard under the Fair Labor Standards Act. It would be implementing a 4-factor test to consider whether there's a potential joint employer relationship, and that's going to be analyzing the power to hire or fire employees, supervise and control employees' work schedules and conditions of employment, determining the employee's pay, rate, method of payment, and which employer maintains the employee's employment records. So that is certainly a change in the FLSA context, and it could have a trickle-down effect in other areas as well. So this is something that the Trump administration is working on revising. At least efforts have been made. But again, at least as far as we're talking about the OSHA sphere, we are still under the Browning-Ferris standard, and the agency has issued these temporary worker initiative bulletins outlining at least what the joint employer standard should look like in those programs that you saw on the previous screen. So with that, we'll turn it over to Kate, and she's going to be wrapping up with just a couple slides to conclude the presentation.
All right. Well, we thought we would be remiss if we didn't at least touch on what's happening on the criminal prosecution front with this administration. Under the Obama administration, Assistant U.S. Attorney Sally Yates, who by the beginning of the Trump administration had become quite well known, but for reasons unrelated to how and why she became well known, in 2015 she authored a series of memos within a few months of each other, September 2015 and December 2015, which when read in combination really put some serious teeth on the effort to prosecute people for worker safety crimes. In September 2015, Sally Yates authored a memo entitled Individual Accountability for Corporate Wrongdoing, and it essentially established a policy by the Department of Justice to pursue individuals who are in any way accountable for corporate white-collar crimes. Following that memo, a few months later in December, Ms. Yates authored a memo that is designed to encourage Department of Justice attorneys to use environmental statutes to prosecute worker safety crimes. So where we've got, say, a worker exposure issue, if there is an overlapping environmental exposure issue, this new policy authored by Ms. Yates says use the environmental statutes to prosecute because environmental statutes, as many of you may know, are just stronger, more robust statutes when it comes to criminal sanctions. The OSHA Act has a very limited allowance for criminal prosecution and penalties, and a threshold for use of that would be you'd have to have a fatality. Also, it would have to be a willful violation. Under the environmental statutes, there's no such limitations, so they're much more broadly applicable, and there's a much longer statute of limitations. Under most of the major environmental statutes, there's a 5-year statute of limitations as opposed to the OSHA Act's 6-month statute of limitations. So we see in, sort of midway through Obama's second term, this shift at I shouldn't say shift, this move or advancement to prosecute, very seriously prosecute worker safety crimes. Another expectation that was not met by at least some employers at the turn of the presidency to President Trump was that those Yates memos would be pulled, that those policies would not be followed, at least with regard to worker safety. However, as of this month, those policies remain in place at the Department of Justice. And based on the work that we do every day, we know that U.S. attorneys across the nation are still pursuing worker safety crimes by using environmental statutes. OSHA is still referring worker safety violations to the Department of Justice for prosecution. There was, in December of 2018, Rod Rosenstein seemed to walk back the individual accountability policy, and that has, at least in practice, seemed to shift some to be not as sort of black and white as the Yates policy, but it's still in place, and the worker safety policy of December 2015 has not been touched. All right. Well, so to conclude, we're just a few minutes, I believe, past our mark of an hour and 15 minutes, so we haven't gone over that much. I'll take just a minute here to I guess, emphasize the theme of this webinar, which is that we have a mixed bag under this president, at least at the Department of Labor, OSHA. Other places, very, very, very different story, but within OSHA, we did have some strong early deregulatory activity, the CRA stuff that we mentioned at the outset. But as we go through these months that turn into years under President Trump, we see continued implementation of certainly the less controversial rules. For instance, the walking working surfaces rule that Micah talked about. But we also see, as Beeta talked about, the implementation and enforcement of Silica, which was a very controversial rule. We also, interestingly, see on the regulatory agenda, which I think we have a slide on here, maybe we'll forward to that for just a second, we see some sort of long expected or long in the works rules still in development. For instance, I draw your attention to the workplace violence in healthcare regulation that is still on Trump's regulatory agenda. Is still there, although moved to long term. Emergency response is on the regulatory agenda. And we've got Lotto modernization and Silica standard for construction. Both of those would probably be considered likely to sort of ease employer burden. But overall, very mixed bag. One of the reasons that we believe we're seeing a mixed bag, and if we were to make predictions or read the tea leaves, we'd have to say that that is what we expect over the course of the remainder of the Trump term. And the reason, at least a major reason for that, is that there has not been anyone sitting in the chair of the Assistant Secretary of Labor, where Dr. Michael sat for 7 out of 8 of President Obama's years in the office. We do not have anyone acting on behalf of President Trump to enforce his agenda and his philosophy. We did have Scott Mugno, who had been nominated multiple times by President Trump and had been cleared by the Senate Help Committee multiple times. However, and notwithstanding a rule change in the Senate that seemed to possibly make it easier to get a nominee in place, confirmed by the Senate and in place, Mr. Mugno recently withdrew his name from consideration. So now I will say that, Scott Mugno is a very serious safety and health professional who would have done probably an excellent job at the agency. But he's no longer in play. So what that leaves is we're 2.5 years into the Trump administration. It's the longest the agency has ever gone in its history without someone sitting in the top chair. And we've got to predict, based on everything we know, that there likely will not be anyone sitting in that chair through the remainder of the Trump term. What that likely means is that what we've seen over the last few years is going to continue at least till the election, and we'll continue to see a mix of deregulatory, moderate efforts with the continuation of rulemaking in some areas and enforcement at OSHA. So, thank you for your time. We appreciate your involvement. We don't have time at this point for any questions, but if any of you have asked questions, we will follow up with an email to you to provide some additional information. And I just want to point out that we do these webinars on a monthly basis. The next webinar we have coming up is going to be an interesting one, and I think a very practical guide for those of you who worry about enforcement, worry about OSHA showing up at your door. On July 23rd, we have a webinar that is going to provide some practical tips to how to deal with an OSHA inspection. Thank you very much, and enjoy the remainder of the summer. Oh, sorry, many of you have signed off, but I just want to make a plug for our second annual Process Safety Summit that will be coming up again this October. We had a very successful inaugural Process Safety Summit last October, and we invite all of you that are interested in process safety management, RMP, please consider attending and participating in the next summit. Thank you very much, and good day.